All right. So thank you everyone for joining us today for our workshop for copyright, trademarks, and etc. for artists. We have here our main host, Scott Brown. He will be walking us through the important aspects that we need to take into account for these categories. But before we get started with the actual workshop, my name is Davon Nichols. I am your grants associate, your point of contact for individual artists here at the Greater Columbus Arts Council. And before we get started, we're going to have a quick moment to have our land acknowledgement read for you guys to show that we're showing sovereignty and respect for the lands that we are occupying. So the Greater Columbus Arts Council collectively acknowledges that the land we are positioned on is the traditional, ancestral, and contemporary lands of Indigenous people. We reside on land that was cared for and called home by the Kaskaskia, the Shawandes, Tula, and the Maamia people and their ancestors. The land was ceded to the United States by Section 11 Treaty of Greenville in 1795. By offering this land acknowledgement, we affirm tribal sovereignty and will work to be accountable to American Indian peoples and nations. In a consultation in Oklahoma in January 2020 with representatives from the 3 Shawnee tribes, the Miami, and the 5 other historic tribes, we were asked to not use the term hopeful to describe the people or cultures, but only to describe earthworks. Hopewell is the name of the white landowner on whose property and first mounds were documented by us and the UK archaeologists. Our tribal partners did not think it right to be designated in their ancestors with that name. Thank you guys for taking a moment to hear that land acknowledgement. So I will go ahead and reintroduce Scott Brown and pass everything over to you, Scott.
Great, thanks.
All right.
All right, am I host and sharing now?
Yeah, you should be fine in us sharing.
Okay, great. So everybody can see my slides then.
Yes.
Awesome. Okay, so yeah, I'm Scott Brown. I am an attorney at Anthony Law. I kind of bill what I do as being an attorney for creative-based businesses. It does encompass quite a bit of arts and entertainment type of law, but I do a little bit more than that as well. So just a little bit of background about me. I'm actually a Columbus native. I grew up in Columbus. I went to Groveport, Madison High School. My mom was the band director there. And my grandparents owned a chain of music instrument stores called Colonial Music. I think they had 7 or 8 stores in Columbus at one point. They actually sold it when I was in college, but basically grew up working in their store. My dad also owned a drum store, and all my family were basically high school band directors. And my grandmother was the first woman in the Ohio Band Directors Hall of Fame. So family of music. So I went to Berklee College of Music in Boston. I graduated in 2006. I play trumpet and guitar. You know, as I said, my family was all into marching band and concert band, but I was always playing guitar and playing in rock band. So I was the weird one. So I went to Berklee. I've played in a million bands. I've done a couple US tours, put out music, doing less these days with COVID. I also had a baby. But while I was at Berklee, which is, you know, full of amazing musicians, realized pretty quick that I wasn't the best musician there or even close. But they had a music business program and I started taking those classes and they were really, really great. And they were mostly taught by entertainment lawyers. So it really kind of opened my eyes to, you know, kind of the legal aspects of, you know, the music world. And so I initially wanted to be an entertainment lawyer. And then as I kind of pursued it more, you know, most of the music I was into is not mainstream music. You know, I was like kind of niche stuff. And I realized, you know, being an entertainment lawyer, kind of the best thing about it would be, you know, like meeting famous people. It's not something that really appealed to me. But I realized a lot of the concepts apply to business in general, right? And that's a good way to think about whether it's a music career or a visual artist career. Do we have any visual artists on this? Or is it most of the musicians? You, okay. I just want to make sure I hit both because it's easy to just talk about music. So,
I'm a visual artist.
Yeah,
oh, perfect. All right. So I will
Yeah.
definitely talk about those things.
me too.
Good. I'm glad I can hear you guys too, so I don't feel like I'm just talking at a screen. Okay, perfect. So I came back to Columbus to go to Ohio State Law School, and I've been here ever since. I graduated in 2011. I'm obviously still a musician, and run venues around town. And like I said, not doing as much as I was, but I want to get back into it as soon as I can, as soon as it seems a little bit easier. So this is a picture of me from 99, 2000. I'm gonna actually use it in the presentation, but I'm probably still that person, really. All right, so and like I said, my practice is broader now. It's more focused on businesses that have a lot of creative bent to it. And certainly music clients and art clients fit that, and I do help a lot of music and art clients. It's Columbus, so there's not a ton of it, and I do quite a bit. Anybody that calls me, I'll usually spend some time with them and help them. So this is very much kind of the stuff that I would talk to people about. So here's a quick overview of everything I've kind of prepared to talk about. I'm going to talk quite a bit about intellectual property, which is the protection behind the things you create, both mostly about how you can protect what you create, but a little bit of avoiding infringing others. That's going to be the bulk of what we talk about. And then I'm also going to talk about potentially forming a business entity, an LLC, to protect yourself and your business, because if you are starting to make money, it is a business and you should think of it that way. I'll also touch on contracts a little bit. It's a big topic and one you should know a little bit about, but then at some point, know when you might want to get help on it. And I definitely want to leave time for questions. I figure you guys will have lots of questions. So we'll definitely do that. And obviously, I don't know if you guys know a lot of lawyer jokes, but every question you ask a lawyer, the answer is always, it depends. So I'm sure we'll be doing some of that. All right, so let's just start talking about intellectual property. Now, people that do intellectual property kind of argue that this term shouldn't be used, but it's so much easier to just talk it simply and try to understand these concepts. So the biggest one for us is going to be copyright. That protects, I'll talk about it in depth, but it's, copyright is movies, music, visual arts. It's the stuff that everybody on here is creating is going to be protected by copyright. Next is trademark. We're also going to touch a little bit on right of publicity. And I'm not going to be talking about patents or trade secrets. Patents protect inventions or processes. So, it's not super relevant to what, artists are creating. And trade secret is more of a business concept that's related to intellectual property. But I just wanted to show you all of them for just to be broad. So I'm going to start with trademarks because I'm going to spend most of the time talking about copyright. So I wanted to kind of just touch on this and then move on. So and all these terms are, a lot of times people kind of throw these terms around interchangeably, but they are all different things. And it's funny, even in people that do this work, even in New York Times articles or something, they use them wrong all the time. So, but they are different. So trademarks are branding. Okay, it protects source identifier, which is going to be like your name, logo. It can also be things like colors and sounds. Taglines are protected as trademarks. I did trademark work at Nationwide for a while, and so Nationwide is a Columbus company. Everybody's familiar with it. The name Nationwide is a trademark. Nationwide is on your side is another trademark. Nationwide, the Nationwide is on your side 7-note jingle is a trademark, and their logo is a trademark. So there's a lot of levels to it. Trademark rights last forever as long as you keep using them, which is pretty unique compared to all the other types of intellectual property. And I will talk a little bit about registration, but registration for trademarks is typically done with the United States Patent and Trademark Office, and that's to get a federal trademark. There's also state trademarks, but there's not a lot of value in it. So it's usually not worth doing and just focusing on the federal.
Mm.
Right. So, oh yeah, one more before I get into copyright. So right of publicity, this is not really a true intellectual property, but it's the idea that everybody, it's actually a constitutional right. Everybody owns the rights to their name, image, and likeness. And it's treated similar to intellectual property. The big thing here would be you can't use, you can't take a picture of somebody and put it in an ad without their permission, and vice versa. Your image and likeness has value and you have rights to it. This is probably most important for really famous people, but it does come up for common people as well. So I have this picture of Kevin Durant here. This is a good example, just kind of thinking about it monetarily. My stats are a little out of date, but in 2017, he made $27 million from his salary playing basketball, but it was estimated that his endorsements were $36 million. So, depending on how you look at it, he made more money from his name than he did for the main skill that gives him a living. And LeBron's in 2017 was 31 million on court, 55 off court. So this is a good thing to point out if you're a photographer or you use people's images in your visual works. They have a right to control how those things are used. There are exceptions and there's fair use, and I'm not even going to touch on fair use today. But for the most part, you need people's permission to use their image. All right, so now let's get to the main stuff. So this copyright. Copyright is the main intellectual property right that's going to protect everything that you guys create. And mostly, and if you're using other people's property, it's also going to be the intellectual property that is being implicated there. So the legal kind of phrasing around this is that it protects original works of authorship, and it includes anything kind of artistic. So things you would think of like books, movies, music, all visual works from paintings, photographs. It also protects, oddly enough, computer software. So coding is protected by copyright, and also architectural designs. So it's pretty broad. A really important copyright concept is that copyright protects the expression, not the idea. So I have the Star Wars poster here because Star Wars, you can make a movie set in space with aliens and people fighting. That's the idea, but the expression is Star Wars. So you can't go and just make Star Wars and use all of the Star Wars things. So it's kind of important to think of that difference. And this comes up a lot, say with, writing, if you're writing music, I'm sure some of you have seen some of the infringement cases going on. There's only 12 notes. There's only so many. Hello? So there's only, there's only so many chord progressions people use. But again, those are kind of like underlying ideas, and it's the expression that's protected. Copyright exists copyright protection does not require registration to exist, and it exists as soon as it is fixed in a tangible medium of expression. So for a song, that's as soon as you record it, if you write down the melody, lyrics, and chords, that would create it. For a photograph, as soon as you take the picture, for visual works, as soon as you create it. There's that kind of common thing people say about mailing a letter to yourself. I've thought about this quite a bit, and I can't figure out where this comes from. That doesn't really do much. Your copyright protection exists as soon as you make it, and as soon as it's fixed in some form. So I think mailing a letter to yourself might prove that you wrote it by a certain date or something, but it's really not, it really doesn't do anything. And there is registration available with the US Copyright Office. And I'll talk about that a little bit. I don't think it's super necessary, but we can talk about it in detail when we get to that section. Copyright lasts a very long time now. Copyright protection lasts for the life of the author plus 70 years. Now, this is pretty remarkable because when the first major US Copyright Act that's been built from, was only 28 years. So it used to be you create something and you could even lose, it would go into the public domain during your lifetime. Then they expanded it to have a renewal period that you had to actually file something to get your second 28 years. So you could 56 years, but then they keep going back to Congress, and they being, big companies that have important rights. A lot of people kind of point to Disney and Mickey Mouse, the Steamboat Willie animated film that he first appears in. It seems like every time that comes up to be public domain, Disney is able to get Congress to extend the copyright. So now copyright is life of the author plus 70 years. So it's long now. All right, so I want to talk about some copyright aspects related to visual arts. So copyright covers pretty much all visual arts: photographs, paintings, digital works, motion pictures. There's a lot of copyright implications with NFTs. I don't know if you guys are into that. I have a client doing a lot with that, so I've been diving deep into the rights issues with it. And I think another important thing to note, and this is probably for everybody, probably everybody should know this. Copyright exists as soon as it exists. The protection lasts life plus 70 years. So pretty much every image on the internet is protected by copyright. The idea that you could just go and grab something off Google Images and use it, it's public domain, it's not true. Copyright attaches and it's protected. And there are like stock photography companies that will go around and send cease and desist letters. They use web crawling technology to look for people infringing their photos. And if you're a photographer, you can do this as well. People are using your photograph, you can send them a letter and demand that they pay some sort of license. And of course, I have used a bunch of photos in this presentation. And since I'm telling you guys not to infringe people's work, and because you guys all create works and I don't want to infringe, I actually got all of these photos from open sites where they allow use of photos without paying. So I got them from Unsplash and a few others I got from random places. But it's important to not infringe other people's work, especially if you wouldn't want people to infringe yours. Obviously, the aesthetics are limited, but that's how it goes. So the last topic on this slide I really want to talk about is a lot of times with visual works, and this can apply to also software and music, if you get commissioned to create something, the default ownership rules are really interesting. So if you are an employee of a company, you're a W-2 employee, and you create any type of intellectual property for the company, the default rule is the company owns it. Makes sense. Now, if you are an independent contractor, meaning you're not an employee with W-2, or you just get commissioned to create something, say you're a wedding photographer, or somebody hires you to paint, paint a painting of their pet or write a song for an occasion. The default rule is actually that you as the creator own the copyright, and the person that commissioned it just has a implied license to use it for the purpose that they hired you for. So, it's important if you are, and I often am giving this advice to business owners who are commissioning works, whether it's art or software or something like that, you have to have something in writing saying they're signing the ownership. So you own that work unless you assign it. So that's something to consider if you're doing some commissioned work. You can actually kind of sometimes negotiate to get paid more to assign the copyright. But it's something that's actually very artist friendly. A lot of these things are not. So that is something to think about. All right, so now I'm going to move to music. So copyright music protects music, obviously. There's a very interesting distinction with music, though. There's different types of copyrights. So if you have a song recorded on I was going to say CD, but that sounds archaic now. Song on a CD. The song itself, the chords, the words, the drum beat, the raw music, that is a song copyright. And that's dealt with through publishing rights. Then the recording itself, which in music industry lingo and in contracts is this sound recordings work with no space, that's a separate copyright. So they can be owned differently. So say an artist does a cover song and records it, there's not a bunch of labels or anything involved, so it's very simple. The person that wrote the song owns the song copyright, and the person who recorded the song owns the sound recording. And so those two concepts are separate and they're dealt with very differently, especially when it comes to the different types of licensing. Now, this is probably like 3 weeks in a semester-long course on this topic. So I don't think we're going to be able to, go super deep on it. But each of these two rights are dealt with very differently, and it's important to kind of understand the difference once you start really diving into all of the technicalities of how music copyright works. So in addition, an analogy that gets used for copyright, you have a copyright, what you can do with it, there's a ton of different aspects. So that's usually kind of the analogy people use is a bundle of sticks. So you have a song and you have a bundle of different rights that you can do different things with. You can license different rights to different people, all different ways. So this includes publishing, the right to put a song in a printed music book, the right to play it live, the right to record it, the right to put the recording up for streaming or to put it on a CD, the right to synchronize it with in a movie or in a commercial or in a video game. So all those things are separate and require different licensing. This is similar for a book. A book, those rights would be the right to publish it in print. Publish it in a digital form is a different right. The right to make a translation, the right to adapt it into a movie. So there's all these different ways to use the copyrights you've created. And for visual art, similar, the right to put it in a book, a collection of art, or the right to, put it in an ad. Those things are all different. All right, so some more music copyright issues. So I talked about the difference between a song and a song recording. Then there's public performance rights. Now, this is the idea of, this might seem weird because you walk around, you hear music everywhere, you go to a venue, you hear music, you're on hold, with your bank, you hear music. But all music has an inherent public performance right associated with it. And you can't technically play music out loud in public or in a venue without permission. Now, this is dealt with kind of in a simpler way, though. Your public performance right is going to be managed by these performing rights organizations. And if you kind of started to dive into music law, music business law, you've probably seen this: BMI, ASCAP, GCAC. These basically, you sign up with them, you give them rights to license to other people to have your music performed live. So this is going to cover both, like if your song's played on the radio, also covers if you play at Ace of Cups, you should be getting paid for that public performance related to your copyrights. So the way this works though, so you sign up with them, and there's two ways to sign up. There's as an artist and a publisher, which is again getting into, complex topics, probably not worth going super deep into. But each of those owners has a right to receive royalties based on public performance. And then, so all these venues in Columbus, from the, maybe not the littlest one, but every bar, all the way up to like Nationwide Arena, they pay license fees to these performing rights organizations. And then, so, Nationwide Arena pays a huge license fee to BMI and ASCAP. And then BMI and ASCAP then distribute that money to the artists in their portfolio that belong to them. So BMI and ASCAP are the big ones. Most people belong to either one of those. It's kind of like Pepsi and Coke. GCAC is a invite only one, and pretty much only really big artists are with that one. But they handle all of the publishing, public performance right publishing stuff. If you want, and you can sign up with them. It's a complex thing, and you got to learn a bunch of stuff about it. But if you're playing live a lot, if your songs are getting played places, there's revenue there that you could be getting. Now, PMI and ASCAP deal with, of course, this has to get more complicated, but they do radio, terrestrial radio, meaning traditional radio, and live. But for digital performing rights, Congress actually created this other entity called Sound Exchange. So that's who deals with like Spotify and Pandora. And if you're getting played a lot on Pandora or in digital streaming, there could be money for you with Sound Exchange. But again, complex. So then the last topic here I have is talking about syncing, and this is a totally different topic than the other things, but there's a lot of money to be made in licensing music to for use in an ad, in a movie, and now with the internet, every business has these little 2-minute kind of videos about their business, and they have to license the music to use in it. So you have, when you own your music, you have full rights to license it for these uses, and there's a lot of money in it. Of course, remember, if you say you want to license a cover song, you're licensing your recording, but then you would have to get permission of the songwriter as well, because you need both to license with video. But if you own both, which most of you probably do, especially with original music, you can license it that way. All right, so a few other copyright issues. Actually, I have 3 more copyright slides, so more copyright. So a really interesting concept, and this definitely applies to music and may also apply to visual arts as well if you're collaborating. How do you deal with the ownership of a work if you collaborated and you wrote it with someone else? And also if you recorded a song with multiple people. So the default rule, so say, I think I'll use an example. So say you're in a, there's 3 of you musicians and you're working on a song together, and one person writes all the music, and another person writes all the lyrics, and another person has some ideas and contributes, 5% of the music and 5% of the lyrics. What is the default ownership? So you might think, well, it should be, the one person gets 5 or 10% and the other 2 split the rest. But it doesn't work like that because it's impossible to delineate that without agreeing. So the default is actually that all 3 people, everybody that contributed, owns it equally. And everyone has the right to go and license it and just make sure they pay the other people. Now, that may not work for you. So it's a good idea if, especially if you're in a band and how you're, that this is an issue, or you're doing sessions and you're collaborating, or, I think this is I have a guy I work with a lot he's a producer, session producer doing hip hop. And, basically people just get together in the studio, get creative, lay stuff down really fast, and they don't think about it, which is the right way to do it. I mean, it's art. But at the end of the day, that default rule isn't really going to work well. So this is the idea of a split sheet. You actually decide how much each person owns, and if there's any additional, if deciding to license is going to take all of you or one person to decide. So it's a good idea to think about that when you're collaborating, what your split's going to be. And of course, it's easy to think that this isn't a big deal, because it's not, because you're making art, you're collaborating, it's presumably enjoyable and fulfilling thing with, people you like, but, it's all good until there's money involved. And then people start, getting upset and making claims. And there's tons of this. You see it with, bigger artists get pretty far along and suddenly people are upset with how they decided to do this or not decide in advance. So definitely something to think about. And then this also applies to any visual art collaboration. This is a big deal for a movie. I mean, think about how many people contribute to a movie. That's all set by contract. You know, who's going to own what their rights are. So, you know, it's always an issue. All right, so another music concept, covering songs. So by default, this should be complicated, but it's actually simple, which is nice. If you own the copyright in a song, you have the right to not let other people play it. But that's ridiculous. So actually, Congress actually took care of this, and you are allowed by statute to cover other people's songs on a recording without having to get permission or anything, so long as that song has been released before. And there's actually an agency called the Harry Fox Agency, and you go to them and you get a license and you pay, and the rate is set. I believe it's like 10 cents for one song per copy of what you produce. So if you produce 1,000 CDs, it would be $100 to have that cover song in there. And you do it through the Harry Fox Agency. You don't need permission of the original songwriter, and they do get paid. So that's why it's no big deal to cover songs. And then, if you're playing at a venue and you cover that song, of course, it's impossible to track this stuff unless somebody submits it. But, presumably you cover that song, the artist should be compensated for the public performance. So those BMI and ASCAP, those fees they collect, they filter them down to the artists based on submissions from radio stations, but also you can submit. That's another thing I should mention. If you do sign up with BMI or ASCAP, you can actually submit your set lists and make your claim to that money you should get. Like I said, the song does have to have been published before, but no fear with doing cover songs. Just check the right boxes and you shouldn't have any issues. All right, so I got this picture of me again. So another interesting thing with copyright is it's not just one copyright. There's many copyrights, and copyrights can be embedded in each other. So there's levels and layers of copyright. So think for example, if you took a photograph of a painting, you've got two copyrights right there. You've got the painting itself, and then you have the photograph with the painting embedded in it. So if you wanted to license that, you would need permission of both. So I think while this picture is ridiculous, it's really interesting from that perspective because there's so much intellectual property expressed in this picture. And obviously, I'm trying to find some sort of identity as a 16-year-old or whatever, but by using intellectual property, but every album cover is protected in there. Every photo, there are tons and tons of trademarks in there. There's logos on clothing. There's a logo on the television. So there's this photograph, and the photograph itself is copyright protected. And the default rule on photographs, by the way, is whoever takes the photo owns the copyright. So, it can get complicated really fast. Also, right publicity. You would need my personal permission to use this photo if you ever wanted to use it for something other than this presentation, which you don't. But I think it's a good illustration of these concepts. All right. So then the big question, there's registration. So should you file to protect copyright? So copyright is fairly cheap to file. There's some different fees, but basically you file some information and the fees are generally about $50, $55. It depends what it is. There's a lot of people out there will tell you file copyrights, do it. You have protection as soon as it's created. And what having a registration does is allows you to sue someone in federal court. So if you've got infringement going on, you need that registration to sue. But until then, it doesn't do all that much. I think filing a copyright is, and some people will say it's very simple and easy. I think it's not. I think it's actually pretty confusing until you get kind of deep into understanding all the concepts. So, should you file a copyright? Maybe, but it's not a life or death thing where if you haven't done it, it's going to hold you back at all. So now for trademark, Trademark is probably more important to get, but not for every situation. So trademarks are more, you file with the United States Patent and Trademark Office. There are filing fees based on the classes, and there's 45 classes that cover various types of goods and services. And it can be a little confusing because these classes were invented in like 1920, and so software doesn't fit smoothly into these. But so for an artist, that's usually going to be 2 classes. There's going to be one to cover your performing, your brand of the services you do performing music, and then another one for any recorded music. Those are actually separate trademarks. So the filing fee for that, it's 2 filing fees, each $250. So you're looking at $500 just to file. It takes a long time and to get it through. And there's some nuance to getting the application right. And if you mess it up, they'll kind of help you, but there's a good chance you could just lose your money. So if you're really thinking about a trademark, it's probably good to hire someone to help you. Excuse me. But it is something I think most people can figure out. But at the same time, the whole point of filing it is so that you can stop someone else. So now if somebody else is using your name and you got the registration first, obviously you win. Now, I have some thoughts on this in general. The last really active band I was in was called Other People. And I liked the name aesthetically for what it meant. And I knew that there were a couple other bands called Other People. Now, I didn't care that much because I had no illusions that I was going to do much more than play some local shows, maybe put some music out. And so I cared more about the aesthetics than having a unique name. Now, somehow our Spotify accounts got mixed up, and now 2 bands called Other People that don't sound anything alike are under the same artist umbrella. I can't, for some reason, I don't control it. And so I can't do anything about it. So what this taught me is, so rather than trying to protect it or, go from the trademark perspective, I think it's probably more important to just have a really unique name. I think artists these days there's artists now where, they have crazy punctuation and weird spellings and things that just, you can pretty much do anything. And I think it's worth it to have a unique name that's totally dissimilar from anyone else, that you Google it, you come up, nothing else does. That's far more useful than filing a trademark, I think, at this point. But if you do start to make some money, people are infringing you, you're having some success, then I think it does make sense. And I'll kind of talk about this topic more at the end, but knowing when to worry about these things or to spend money or time on them is important, because you should be working on your craft and building a business, not necessarily worrying about some of these details. All right, so totally switching gears here. So we talked about everything with copyright and trademark. So another thing, so this is more where you're thinking about, what you're doing as a business. Okay, so a lot of people, might hear you should form an LLC, and there are certainly good reasons to do this. If you're making any money at all, it's probably a good idea. Or if you're, doing another type of business. So a LLC stands for limited liability company. And the most important part of this is the limited liability concept. So this means it's a separation of your personal assets from your business assets. So say something's going on, you have an LLC, it's a business, and something happens where something goes wrong and that business owes somebody a bunch of money. They can't go after your personal stuff for that. They can't go after your house or your car or your equipment or anything like that. Only the assets of the company. So that's why it's good to have it, because it keeps their protection separate. Now, it's actually really easy in Ohio to get an LLC. You file with the Ohio Secretary of State. It's $99. You barely have to give them any information, and you've got it. I do it all the time in Ohio, and I do work in other states too as well, and it's a lot more complicated in other states. So it's super nice here because everything's very business friendly here. And then to continue kind of building the LLC, creating it, you also need to get an EIN. That is basically that's the business's social security number. That is, you don't want to use yours, you use the business's. Sorry. And then from there, you can open a business bank account. Now, the important thing about your limited liability protection is you want to keep that asset separation. You have to keep your finances separate. So you shouldn't be, if you get a business credit card, you shouldn't use that to pay for personal things or do personal things with the business account. You're supposed to keep them very separate. And the other thing is you might need an operating agreement. This is really important if you have a business with multiple owners. It sets out kind of all the rules between the owners, who owns how much, how you deal with certain situations, what happens if someone dies, how you make decisions. If it's just you though, obviously this is very easy. So like I said, you file in Ohio, and it's only $99, and they usually stamp it in about a day. So it's really not hard to do or expensive, but it does help to kind of understand it. And then in addition, if you get to this point where you're forming a business, accounting becomes really important. And if you're making money doing music or visual arts, you're a business, and that also means you have to pay taxes on your income. But there are tons of ways to limit the taxes you're paying through deductions. All your mileage driving to and from a gig, all the money you spend on art supplies, that stuff can be deducted. You can also depreciate equipment, and a good accountant can really help you with that. There's some people in Columbus that kind of specialize in this. There's tons of resources online. I've got a slide with some resources about this stuff, but there's a lot of ways to limit your tax liability, and you don't have to have an LLC to have it, but these things kind of go hand in hand once you're kind of to that point of doing this. All right. All right, so contracts. What is a contract? So a contract is basically any agreement between two people that would be enforceable. So this is typically going to be about selling goods, providing services, and you do not have to have a signature for a contract to be valid, generally. Oral contracts are enforceable. So if I said I was going to buy your car for $500, you have a contract. But there are more complex contracts that require more, for example, a contract longer than 3 years needs to be signed and notarized in Ohio. And, the deed, title to a car has to be notarized. So there are rules about it, but in general, no, an oral contract is enough. Now, what's tricky about an oral contract is it's not going to have every detail, and that's where signed contracts kind of can come in. So now, there's all different types of contracts. I mean, you guys enter into them all the time. You agree to a contract to use Zoom through the terms of use. If you finance a car, you agree to that contract. If you even if you bought a guitar at Guitar Center, there's terms on the receipt that apply to it. That's a contract. So they're everywhere all the time, and they're all super boring, and no one reads them. And they're written in a lot of times in kind of archaic legal language. And the reason for this is, the point of the contract and the language in there is supposed to be predictable, so and enforceable. So over years in history of law and contracts and litigation, certain phrases and types of writing have been kind of deemed to be unambiguous and more enforceable. It's kind of where legalese comes from. Once you kind of work in it, it makes sense. But obviously it can be daunting because it's just not how people talk. And it's very unartistic as well for the most part. But, that's kind of why it's like that. There's a lot of movement in the legal industry to try to have more straightforward contracts, and you see things all over the place. It's a great idea. You want things to be understandable, but you also want them to be enforceable. So, where do you start if you think you need a contract, or a new one, or a contract related to something you're working on? You may get a contract put in front of you if you're playing a big venue. It's going to have a bunch of things. If you're ever going to sign a record deal, you may have a contract put in front of you. If you're being commissioned for a work of art or photography services, you probably want your own contract put in front of them. There's a lot of power in who brings the contract in a negotiation. And so, contracts are not protected by copyright. It's all out there, and you can go and find examples of contracts when you need one. And I do this, certainly. I'm not typing contracts. I have forms for every type, and I tailor it to the needs of the situation. But this can be, tricky if you don't have a lot of experience doing it. So, you can go and find these things and find a good place to start, and that's great. But then you have to be really careful to make sure that there's not something in there that isn't what you intend. If you get a contract and you start with a form for something, you want to make sure you read it, you get rid of stuff that doesn't sound right, or you change it to be what you intend. Now, of course, at some point you're going to go, do I need help? Should I hire a lawyer? Is it rising to that level where just doing it yourself is too risky? And of course, it's going to depend on your ability and sophistication with it. And then also, lawyers charge money, and for a contract with $300 at stake, it's definitely not worth it to hire a lawyer, right? I would say until you get to like $1,000, I wouldn't even consider it. Try to learn, do it yourself, do as much as you can yourself with all of these things. And then, only when it makes economic sense to get help, then would you do it. So I have a couple of examples. So, contracts that a musician might have sign or get put in front of them, big gigs, a record deal, publishing deal. If you're gonna get your song in a movie or a video game, there's going to be a sync contract. And then visual artists, they're licensing the work for anything. And then also those work for hire situations where you're being commissioned, and they're probably going to put some sort of assignment. So a big thing too, if you own the copyright in something and you're going to sign a contract related to it, the biggest thing you want to look for is, do I still own it, or am I assigning ownership? And that's the most important thing. And and it's context based, it might be worth it to sell it depending on where you're at in your career, what you feel about the work and how much money you're getting. But, that's always those 90s VH1 Behind the Music episodes, every single one of those people are like, I didn't know what I was doing and I gave away all my songs. That's the thing you want to watch out for. And, if it's enough money at stake, consider getting help. There are, I think there's probably 4 or 5 attorneys in Columbus that know this stuff and can actually help. And I know most of them because it's a small world, and they're all very reasonable and want to help. There's a couple artists I work with all the time that I just help them out whenever they have something going on. So it's a good way to give back, and people, the music and arts lawyers in Columbus are very approachable. So me and all the other ones. All right, so I kind of started to touch on this already, but how much do you need to worry about all this? And this is kind of advice that I give to anybody with a business. I've seen people get too bogged down in dealing with legal stuff and formality that they don't just get going on what their whole goal is. But at the same time, you don't want to put it off forever and never, get caught too late, not having protected anything, or, made a bunch of poor decisions. So, it is an art to know. I think educating yourself, presentation like this is obviously, of course I would commend all of you for attending this. But don't get too bogged down in it. And this is different with different people. Some people wait too long, some people don't. Some people do way too much too early when they really should just be getting going on what they're working on. So there's definitely an art to that. And I think, if one of those sounds like you, where you're doing too much worrying about this stuff and not enough about developing your craft and building that, maybe, you know, pull back a little bit on this stuff and focus on that. Or, you know, if you're feeling like, oh, I'm missing out on opportunities or I'm making mistakes, you know, learn more about this. And I think this is relevant for every business and everybody and everything. You know, you don't want to just get tied down with administrative stuff all the time. All right. So of course I realized I put web links here over top of this picture and they're completely impossible to read. So try to distribute these somehow. Oops. But this is just a total random list of resources that I think are really valuable and that can be really helpful that you may not be aware of. So first, for the music people, this book, All You Need to Know About the Music Business, is like the Music Business Bible. It gets updated every couple of years with all the new concepts. When I went to Berkeley, this was like basically the classroom book, but it has everything in it. And I think it might even have some sample contracts. That's definitely where you start. Also, I included this Music Bed is a good resource. There are other places like this, but you can go and put your music on there, and people who need music for licensing, for YouTube videos or all kinds of different things, they can go and get music there. So, you know, if you've got some good licensable music, you can make some money through that. Then I have a link for some other industry resources. And then the last two are, I mentioned the tax stuff. If you are making enough to pay taxes on what you're doing, you want to cut down your tax bill by deductions. So I found a really good link that TurboTax did on musician deductions, how to do that. And then this other one for visual artists. So I'll figure out a way to kind of share those, whether it's the slides or just these links. And then I am ready to do questions.
Wow, thank you. That was a lot of great information.